Dear IFA friends, a very warm welcome to IFA's first international event of 2021. This is our European region's virtual conference on reshaping the EU own resources and its impact on third countries. I hope that many of you will have found the time to enjoy Global IFA's virtual programme in November. This was our response to the deeply regrettable need to postpone our flagship annual Congress in Cancun because of the pandemic. Of course, we greatly missed the opportunity to get together in person, but the scientific content was superb and the IT worked for us. Indeed, 2020 saw the cancellation or deferral of numerous IFA events, whether globally, regionally, or nationally, including the European region's own conference in Milan last May. But the wide range of agile and innovative responses, making the most of the new technology platforms such as Zoom and Teams, has been truly excellent. Central IFA's own response has involved the launch of Studio IFA, our new video conferencing facility. This provided the foundation for the November virtual programme and is being used again now. Great thanks are due to the IFA Secretariat for the skillful and speedy construction of this platform. It will be of ongoing, multifaceted use for our events. Throughout 2020, IFA has remained at the heart of the international tax policy debate. As the pandemic drags on, it's terrific to see our momentum maintained early in this new year by this European region event. My thanks to all those who have been involved in preparation and presentation. Today's subject matter is given particular energy and relevance by the global economic crisis caused by COVID. The concept of EU own resources to finance the EU budget has been with us for more than 50 years, traditionally based on certain customs and agricultural duties and levies, VAT and gross national income-based contributions. For a while now, a basket of new means of generating certain own resources has been under discussion, potentially including revenue from the emissions trading system, a slice of corporate income tax from the CCCTB, if and when implemented, and a contribution scheme based on non-recycled plastic waste. Last year, in the face of the pandemic, the Commission proposed the underpinning of the multi-annual financial framework with bond issues of 750 billion euros and possible new streams of revenue, including a carbon border adjustment mechanism and a digital tax on companies with global annual turnover of more than 750 million euros. The plastics levy is implemented from the 1st of January 2021. European digital taxation, of course, sits uncomfortably alongside the long-standing OECD Inclusive Framework project, despite the compatibility claimed in the recent EU Inception Impact Assessment. The Pillars 1 and 2 blueprints were the subject of public consultation meetings only a few days ago. Today and tomorrow, the Inclusive Framework is holding an open meeting, which naturally is in virtual format like everything else. As so often, eyes will be turning again to the United States, in particular the new Biden administration, to assess any possible changes of tone or emphasis towards the OECD digital proposals. For the moment, retaliatory tariffs on France have been paused, but the US views some DSTs as discriminatory, so significant tension remains in the room. So, all in all, your discussion topics today are right at the sharp point of dynamic international tax policy. Governments everywhere continue to hemorrhage money, and eventually budgets will have to be restored to sanity. Global politics and macroeconomics are in the furnace of a world health emergency. Against that dramatic backdrop, I am sure we will profit greatly from the discussions which will follow in a moment. You may think it ironic that a post-Brexit Brit is opening proceedings of this very EU-centric conference. But wearing my IFA hat, or at any rate my IFA tie, and speaking through the Studio IFA platform, I am spiritually very much in Rotterdam. I look forward to being virtually with you for the rest of the event.
Well, Good afternoon, ladies and gentlemen, or morning or evening for participants from outside Europe. It is a pleasure and an honor not only to be present in this present this joint seminar of IFA and EATLP, but also to see that a collaboration that was initiated some time ago is bearing fruits and contributing to face and reflect about real-world challenges and issues. Or in this particular case, one of the most difficult challenges the European Union will confront in the post-COVID world, whether the European Union can levy its own taxes and is able to overcome the double unanimity requirement, harmonized taxes, and European Union new own resources, and what those new taxes should be. This is a topic truly fundamental. It goes very much beyond the tax dimension and reaches the constitutional dimension of the European Union. In a post-COVID European Union, where the ethos of the Union has been rapidly transformed due to the COVID outbreak, we are facing new challenges. And probably the most important one is how to have a European Union that is more committed to solidarity, to democracy, that is more robust, accountable, and transparent and closer to the citizens of the Union. Even if speaking about new taxes in the midst of a crisis may seem impolite, it is a debate that institutions that really have the aspiration to truly represent citizens cannot avoid. And it is precisely those ideas and finding the right balance between both ideas what we are going to speak about this afternoon in this jointly organized seminar by IFA Europe and the European Association of Tax Law Professors. The collaboration between IFA Europe and EATLP started a couple of years ago when my friend, colleague, and also associate of the European Union, of the European Association of Tax Law Professors, Professor Guglielmo Maestro, reached out and proposed me right before the Congress in Warsaw, in Poland, to work together. In that Congress, in which I had the opportunity and the privilege to intervene as a speaker too, we were discussing about new forms of collaboration, and we finally signed a memorandum of understanding whereby our organizations would help each other in the design of the programs of our respective congresses, would also help in identifying speakers for those congresses, and would participate in the deliberations of their respective scientific committees. We've been doing that in the last couple of years, and last fall, the idea came up of organizing a new event jointly by both organizations, to which EATLP, in particular, the president, myself of EATLP and the executive board, immediately acceded because we think it is fully in line with our goals as association. EATLP is an organization of tax law professors, currently having about 350 members from all over the world, but especially it is a lively organization that is eager to engage in scientific debate with institutions, with society, with international organizations, and this is what we want to do, and this is why we are thankful to IFA Europe for organizing this event together with us. In this specific field of own resources of the European Union, we decided to set up a specific working group chaired by Professor Franz van Stendal, and we started our works last summer, and Franz will speak about his ideas and the ideas he has presented in this group. Last but not least, because I don't want to consume more of your time for the scientific debates, I'd like to thank IFA Europe, and particularly Guglielmo Maestro, all the speakers for their efforts to the presentations that they will present later on. and all the staff of IFA Rotterdam for their hard work this afternoon. And especially, I would also like to thank all the participants that make this event possible. I'm sure you will enjoy the discussions this afternoon. Thank you very much.
Thank you, Adolfo. I'm very pleased about the achievement of this cooperation that we are just starting right now with this webinar. I believe it should be a great event. Just a couple of words on the European region before we move on with a very short introduction before I give the floor to our chair, Professor Danon. The region was set up in 2 years ago, in 2018, at the Seoul Congress. We worked together with approximately 30 European branches of IFA, and we are trying to put together topics and subjects which may be of interest for the region. The cooperation with the European Association of Tax Law Professors is one of the achievements of the region. We have next steps which we have considered. The first one is a study of the region on taxation of frontier workers, which is the result of a questionnaire which was contributed by 30 regions, 30 branches of the European region. And we have a study which is undergoing and which should be delivered, hopefully, on the occasion of the opening of the annual Congress of the European region, which is the Milan conference, originally scheduled for May 2020 and then moved to 2021. We also have a scholarship program consisting of a temporary research position starting in 2022, precisely at the International Bureau of Fiscal Documentation, as it was done for other regions of IFA and also for Central IFA itself. Let me go now through the reasons for this topic, for this webinar, the EU own resources. Everything started in July of last year when the Council, as our President Mary Clayson indicated, announced the reshaping of the EU own resources. And very timely, that announcement was followed in December of 2020 by a decision of the Council. And the decision of the Council is confirming what we call traditional resources of the European Union, the custom duties, value-added tax, and gross national income, a percentage of gross national income. And as from January 1st of 2021, we have what we call a placid tax. You can see the red icon on the screen, which is not really a tax, it's a levy on the states. It's not really a tax levied by each state of the Union. Next slide, please. And we have a plan also, which is included in the decision of the Council, and which is also the result of an agreement, a political agreement between the Council, the Commission, and Parliament. It is basically two steps. The first one is between 2021 and 2023, a proposal to be made by the European Commission by June on 3 different levies: the carbon border adjustment mechanism, the digital levy, and the emission trading system. And once the proposal is there, then the expected, let's say, process would take place for the decision to approve those levies with an envisaged entry into force on January 1st, 2023. That is only the first segment of the plan. There is a second segment of the plan, and we can move to the next slides, which is for the period 2024-2027. Again, it is envisaged to have a proposal by the Commission by June 2024, shaping some new resources, which might include either financial and/or financial transaction tax, a CCTB, or other form of levies to finance the EU own resources, and the expected and perhaps ambitious entry into force of such levies will be January 1st, 2026. So we are discussing today this subject, very timely, I would say. We were lucky enough to have the Council work in our favor, and having taken such a decision precisely 1 month before our event. So thanks again, if I may say, to the audience, the speakers, for coming here today. And then I only have to give the floor to our chair, Professor Robert Danon. Thank you.
Thank you very much, Guglielmo. Thank you very much indeed for the introduction and for putting together such a timely program. Many thanks, first of all, to the European region, and also to EATLP for joining us for this event. The chairman, Adolfo, mentioned a collaboration between the European region of IFA and the EATLP. It is my desire and hope that this collaboration will be able to be extended more generally within IFA, because as it was indicated, to a very large extent, we pursue common goals. So I see this collaboration today as opening the potential for future and wider collaboration between EATLP and IFA, and therefore delighted. As it was mentioned in the introduction, the topic deserves fundamental attention for various reasons. It is at the intersection of fundamental issues. It raises fundamental constitutional problems within the EU, but it has a wider dimension, as it is also at the intersection of not only the current worldwide pandemic, but also ongoing international tax policy discussion, namely in particularly those relating to the digital economy. So before we first start with the first session, let me perhaps remind you of the program and how it was shaped. The idea of this afternoon's program is perhaps to get started with a setting of the scene, and then you will see that we will have a session on the green taxes in the form in particular of a Q&A, raising the difficult questions and perhaps also speculating a bit. And then we will move on to the CCCTB, the digital services tax, and see how this fits into the debate. But as I said, the most important thing to begin with is to set the scene. And for that, I am delighted to welcome Professor Frans van den Stijl, who does not need an introduction. He is a member of the IFA family, and of course, as was mentioned, he chairs the current working group on the subject matter of today within the EATLP. He is an emeritus professor at KU Leuven in Belgium, and he will be dealing with the topic of the institutional obstacles to financing the EU recovery plan. And some of the questions that he will be addressing in his presentation, which will be displayed on the slides, as you will see, will be: why new resources for the EU budget? What are the solution for the EU budget? What are the obstacles? And what about the unanimity rules? So these are some of the questions that he will be raising in his presentation. So with that, I give the floor to Frans van den Listel for this opening presentation. Thank you very much, Frans.
Okay, I hope that you hear me now.
Yes.
Okay.
We do.
Thank you, Mr. Chairman. Dear colleagues and friends from IFA and EATLP, I'm very happy to talk to you about this subject because this has been my subject of study for more than a decade already since the financial crisis. I would like to answer a few very fundamental questions. Why there are new resources, and how we can introduce those new resources, take into account the rules that are actually in the European treaties. So the first question, why new resources? And that's self-evident. There is a quantum leap in the borrowing capacity of the EU. Traditionally, the EU had a borrowing limit of $12 billion. But in July of last year, the EU decided in the COVID recovery plan to borrow $750 billion. And that is of a different order. So the loan ceiling exploded from 12 billion to 750 billion. And then also the question was, where should these loans serve for? Because the repayment of these loans was no longer an obligation of the member states, as it was in the financial crisis. But the repayment of these loans would be a charge of the EU budget. And finally, the third thing was that some of those loans were not subject to repayment, but because they were grants. So the EU and the member states could spend freely that money without any repayment, and the repayment finally of the loan would go to the EU budget. How was this resolved? Next slide, please. The solutions for that was the EU deal, and the dates, of course, on this slide are not correct because it should be the 21st of July 2020. The date on it was our rehearsal date last week. So that was a mistake. And the solutions were both on the spending side and on the revenue side. On the spending side, there was the authorization by the political deal to borrow 750 billion, 360 billion in loans and 390 billion in grants. And the repayment of those loans, not by the member states, but by the budget, as I told you. On the revenue side, there were also new proposals, but because it was quite clear that the annual budget of the EU, which is only about 166 billion euros the last time in 2019, would be unable and totally incapable of repaying all those loans and all the meager interests on those loans. So therefore, there is an annual ceiling on the EU budget, and that is 1.2% of total GDP of all the member states. That was increased to 0.4%, but temporarily it was increased up to 2% of the EU GDP. And that means an increase of 75% of the annual EU budget. And the next thing was that on the revenue side, there was a proposal to have new taxes, EU taxes. And they were mentioned: the plastic tax, the carbon adjustment tax, the digital levy, the European trading system, and possibly also the financial transaction tax. The Cctv, the Common Consolidated Corporate Tax Base, was mentioned also in the proposals of the Commission before Corona, but that was not in the political decision of the 21st of July of last year. Why these new taxes, and why couldn't we just extend the existing own resources of the EU budget? Well, one of those resources is customs duties. Of course, it is totally unthinkable that the EU would increase its customs duties by 75%, because the only customs duties that the EU levies today are with third countries. And raising those customs duties by 75% would be an outcry in the whole world. The other EU budgets, the sources of the EU budget, are the value-added tax, the common base of the value-added tax, and just a contribution on the national income, or so the GDP of the member states. Now, these taxes, these own resources, they have the effect of an EU tax on the national budget, because they are not really own resources of the EU. They are national resources which the member states will transfer to the EU. And that's why every year the EU is caught in this Wto dilemma, because member states are calculating what they transfer to the EU and what they get from the EU. So that was the reason why there were new taxes. And then the next question is, okay, new taxes, but what are the obstacles, the legal obstacles to those new taxes? And there are two. One is that for the harmonization of taxes, you need unanimity, a special legislative procedure. You need unanimity of all member states. And for the change in the own resources, you have a special article in the TFU at Article 311 stating that you need unanimity, you need consultation by the European Parliament, and you need also an approval in accordance with the constitutional requirements of all the member states. That unanimity existed on the 21st of July of last year. However, how long will it last? That is the question. And so the question is, do we need unanimity for all these taxes? And I think we have to make a distinction between the green taxes and the other taxes. Because for the green taxes, for the introduction of fiscal provisions with respect to the environment, which usually green taxes are considered to be a fiscal provision, Article 192.2 of the TFU authorizes a special procedure, meaning unanimity of all the member states, unanimity to take all these environmental measures. But the last sentence of that article also allows the EU, with unanimity of all the member states, to change that rule into a qualified majority rule. And so the question is, maybe fiscal provisions could be introduced by qualified majority. And that could be the case for the carbon adjustment levy and the plastic tax. However, when you have a green tax, that does not mean that you can use this green tax for the own resources of the EU budget, because that's another article, and that's Article 311. And that, as I told you, requires unanimity of all member states, plus all the approval by the member states in accordance with the national constitutional requirements. So the question is, you can only have green taxes as own resources on the condition that you change the treaty. So what are the conditions for changing the treaty? Well, in the Treaty of the European Union, it's quite clear. There is a very heavy procedure. You have an intergovernmental conference, etc., etc. And we have witnessed this is a complete fiasco at the beginning of the century. So we are not going to use that treaty change. But there are simplified treaty changes possible. Article 48(6) of the Treaty of the European Union says you can do a treaty change without an intergovernmental conference. However, the problem is that that article is not applicable to the own resources, because the own resources is part 5 of the TFEU, and Article 48(6) is only applicable to part 3 of the TFEU. But there's another procedure, Article 48(7). And there you can change the unanimity rule into a qualified majority rule, or the ordinary procedure, which is also a qualified majority, the special procedure, also a unanimity rule, into an ordinary procedure, which is a qualified majority rule. But Article 353 of the TFEU says that doesn't apply to own resources. So we are stuck, or at least apparently we are stuck. Are we stuck? There is Article 2(6) of the TFEU says that the arrangements for exercising the EU's competences is determined by the provisions of each area of the treaties. And here we have 2 areas of the treaties. We have Part 3 for the environmental taxes, and we have Part 5 for the own resources. And what do we see? There is a contradiction between Part 3 and Part 5. Part 5 says you cannot change own resources except for unanimity. And that means if you want to change that unanimity, you have to have a full-blown change of the Treaty of the European Union. Yeah. However, Article 192(2) says, it states, you can introduce fiscal provisions, and you can change that unanimity rule with a unanimous decision in the Council. And then you can provide green taxes as an environmental measure. Yeah. So there is a contradiction. 311 adamantly requires unanimity, but 192(2) says you can introduce that. And then the question is, what is the sense of the treaty? does it make sense to introduce green taxes for the exclusive use of the EU budget, as the Council has done on December 14th last year, and then say you can introduce those green taxes by qualified majority, as Article 192.2 of the treaty is saying, but you cannot introduce those green taxes as an own resource for that budget. Does that make sense? The answer to that is prima facie. To me, that does not make sense. It may make sense if the contribution to the EU budget would be by national taxes, which is more than 3/4 of the total contribution of the budget, as I told you. But basically, the plastic tax is not a national tax. Its rate, its base, its scope are determined uniformly in the EU by the EU Council. So in order to protect national taxes, you can say, well, yes, of course, own resources, they need the protection of the member states. But this is a purely EU resource. So do we need unanimity? That's my question. Do we need unanimity for the other taxes? Well, for the other taxes, there is no Article 192.2. Right? So the answer is legally, in order to be able to introduce those other taxes, particularly as own resources, but just to introduce the tax themselves, it looks as if we need unanimity. However, there's a question, because one of the own resources is customs duties. And what is the procedure for approving the tariffs in custom duties and custom duties rules? And there we have two other articles. Yeah? And here, the custom duties are the real EU tax. Yeah, they are the EU tax. And it is decided that the Council of Ministers, they will change the tariffs. And the ordinary procedure with qualified majority in the treaty allows to regulate the customs cooperation. So for other EU taxes, there are no rules in the treaty. Probably because the treaty fathers in 1957 could not imagine that one day we could talk about purely EU taxes for an EU budget. Yeah? So there is no prohibition for that in the treaty, but there is also no authorization in the treaty. And then the question is, what is the sense of draining tax resources? And I'm thinking specifically about CCCTB from cross-border activities, yeah, to national budgets. Because many European multinationals have grown, have become great, have become powerful, thanks to the internal market. And the engine of the internal market is not so much the member states, it's the EU. Yeah? What is the sense of having the benefits and the profits of the internal market being taxed away to national budgets? Whereas the engine for these benefits is the EU. Shouldn't, accordance to the benefit principle, which is a principle of taxation, shouldn't have the EU some benefit from those taxes if they are purely European taxes? Yeah? And that's also when we have the discussion of CCTB in a couple of minutes. The Cctv proposal was a proposal for the harmonization of national taxes. What we need is not a national tax for a national budget, what we need is a European tax for a European budget. And I think that is a question which I would like to have answered in the next discussion. Thank you very much for your attention.
Thank you very much, Frans. This was an enlightening presentation. Before moving to the next presentation, if you allow me one question. What strikes me from your presentation, being myself a non-EU member, citizen, is that it seems that the constitutional foundation in the end of all of this seems to be extremely fragile. It could go either way. So what's your prospect? What's your vision on this?
Well, I repeat what I just said a few minutes ago. I think that in 1957, people could not imagine that one day there would be an EU budget that would represent, with the approval of the member states, 2% of total GDP annually. And the question is, how should you finance this? And the reasonable answer to that, of course, is, okay, let's finance it with revenue that relates to the existence of Europe as a market, right? Not with the national member states. It is not the economic activity for which the national member states are responsible and have the power to regulate. That is not where we should have the European resources. We should have the European resources. But the problem, and of course, it is, in my view, it is quite comprehensible that even the most idealistic and most convinced federal Europeans that were there in 1957 could not think of that, right? And I must say, I do not belong to that crowd, not at all. But let's save a reasonable solution to that problem. And the reasonable solution is not that the member states from their own resources should contribute to the European resources. The reasonable solution is that Europe itself should contribute to those European resources.
Thank you very much. Thank you very much, Frans. Okay, so I think it's time to move to our next session. Let me introduce the panel of this session. As I said earlier, we are gradually moving into the specific items of the debate. So we'll focus first with the green taxes, from the plastic tax to the carbon adjustment tax. And what we decided to do essentially is to have, first of all, a Q&A session, which I'm sure you will enjoy. But before that, let me introduce the panel. So we have Anne Teuvens, who is a global tax policy manager at Royal Dutch Shell. We have Vicente Hurtado-Roa, who is the head of unit at the European Commission. Joachim English from the University of Munster. And Amanda Varma, a partner at Steptoe in DC, Washington, and Chi-Soon Choi, who is a European counsel at Scudden, London. So perhaps to begin with, we will have a Q&A session between Anna and Vicente. So Anna, please, the floor is yours.
Thank you very much, Professor Danon. I hope you can all hear me.
Pretty much.
Very, very good. Thank you very much. It's my great pleasure to participate in this discussion and this debate today on the EU own resources. And so as said, our topic will mainly be the Carbon Border Adjustment Mechanism, or the CBAM, as it's very often referred to for short. And I'm very happy to be asking questions, or to be able to be asking questions to Vicente Hurtado Rao from the EU. So we'll hear what he will have to say about this, because this is a subject very much under development. And before we start, just quickly where we are on this. So there has been an inception impact assessment that started in the second quarter of last year, which ran somewhere until April for certain comments. And then there was a public consultation rounds on the subject that was done, that was very interesting, and that ran until November of last year. And so currently there is a lot of development being ongoing with the EC, so a lot of input received and assessment. So that's why I'm very happy that Vicente Hurtado Rao is here today to provide some additional impact. So with that, what I would like to do is move to our first question, Vicente, is to maybe start with what it is, maybe just briefly, what is the Carbon Border Adjustment Mechanism? So what is it intend to do, in the sense, what is the objective, what it's supposed to achieve in order, as this is a very new instrument?
Thank you very much. Good afternoon, everyone. And I would like to first thank IFA for the invitation today to be able to present the reflection so far on the introduction of a CBAM. I mean, it's very important for us to reach out to experts like you, to make you understand what we are considering at this moment, and also to talk about the timeline. I mean, you presented already the timeline. I think that's great, and that's what we have presented in our inception impact assessment, and that's what we are intending now. So to come with a proposal by June. As you know, there will be a very holistic package on energy and climate policy in June, including the revision of the emission trading scheme, but also the review of the Energy Tax Directive, where I am responsible, and why not, also the introduction of the Carbon Border Adjustment. You possibly heard, because you have already been exposed to the CBI before, I don't think you are completely new, that the main objective of the measure is to reduce carbon emissions globally, not only in third countries, but also in the European Union. So contributing to the efforts of the European Union to reach the ambitious target of reducing emissions by 2030 of already 55%, which is quite high. Now the level of ambition was set at a reduction of 40%. And also, of course, the objective is to contribute to the climate policy, or the fight against climate change. We know that the fact that the European Union is increasing the level of ambition while third countries are not doing their part, will have an impact on the EU industry. And to the extent that all the efforts done in the EU might be completely watered down, because there might be an increase of emissions in third countries. That's what we call the risk of carbon leakage. It could be in the way or in the form of companies moving out to third countries, which have less strict climate policy, or just investment moving to third countries. What in the end would mean that even if the European Union increases its level of ambition, the fact that the rest of the world doesn't do the same will result in any global increase of emissions. So this is why the European Union has considered from the very beginning of this college, that all started with the political guidelines of President von der Leyen. So the Commission has considered the introduction of the CBAM that could be a complement to the ETS in the European Union to deal with climate change. I want to clarify that the objective is not to protect the EU industry. Very often I hear this. It's not a question of level playing field. It's not a question of protecting our industry against industry from other countries, but it's to make sure that all industry in the EU, outside the EU, make their efforts. We know what are the limits to our ambitions with the CBAM, and at least what we want to make sure is that imports into the EU will have the lowest carbon content as possible, and also in any case that they will have paid the carbon price that corresponds to the carbon content of the goods imported. I also hear very often that we want to introduce the measure because we want to get revenues, and this is also the point of the discussion today, new own resources. It's true that the three institutions have agreed that the revenues from the CBAM, once introduced, should become a new own resource of the EU budget. But I have to say that this is not the objective of the measure at all. By pulling the revenues from the measure into the EU budget, there would be the opportunity to recycle these revenues into measures through the Just Transition Fund, for example, but also other measures with the countries in order to support the movement or the passage to a greener economy. So very, very clear, in any case, no competitiveness objective, and no, and the objective is not to make an own resource from the CBAM.
Vicente, thank you very much. So but it seems like you mentioned it links, it wants to ensure the lowest carbon content products making it into the EU, and basically ensuring that more people or more parties in the world apply low carbon standards, or basically ensure that there is a carbon reduction because the EU is moving faster. Now, what does that mean? How would industry see it? Would this be something that all industry needs to follow up in the sense that would it apply to all products? And also, what is the link? You are head of unit of the indirect tax group, Save VAT. But how did this end up with you? What is the link with tax? Because this seems to be an adjustment mechanism that is more economic in essence.
Well, that's a very good question. I mean, if you remember the political guidelines that I mentioned before of President von der Leyen, before the European Green Deal communication was adopted, she was referring to the measure as a carbon border tax. Because of that, I understand that Commissioner Gentiloni, who is responsible of economic affairs, including also taxud, so taxation and customs union, he was charged with the objective of launching the analysis, the study on the introduction of a carbon border tax. Now we call it a carbon border adjustment mechanism. The change in the name came in the preparation of the European Green Deal. But of course, he was asked to work very closely with two other vice presidents or commissioners. So Executive Vice President Timmermans, because he's responsible of climate policy. And now, because at that time there was a commissioner for trade, but now the Executive Vice President, also Dombrovskis, who is responsible of trade policy, because the measure has to be WTO compatible, also compatible with other international engagements. So from that moment, DG Taxud, me in particular, was asked to work on the preparation of a carbon border adjustment mechanism. It could mirror, I mean, in any case, we know that it has to mirror the emission trading system, because this is the carbon price which is in place in the European Union. And then we started considering, and this is part of our impact assessment, different possible design tools, from an import tax, a consumption charge, something like an excise duty or an internal charge or a green VAT. And also we are considering other measures which are not taxes, like a sort of participation in the EU ETS. Could be full participation of the importers as if they had produced in the European Union, or another possibility is what we call for the moment the notional ETS. It means that there would be a sort of parallel ETS market for exporters from third countries, so that they have to buy also certificates in the notional ETS and surrender the certificates according to the emissions for the production of the products. I cannot give you a definitive answer, because we are still working on the different measures and the different pros and cons with those measures. But of course, the fact that it could be a tax, or it could be something which is closer to the ETS, will have, of course, an impact in terms of many things, not only in terms of the implementation of the measure, but also, of course, in terms of who is mainly concerned with implementation, what is the legal basis Professor Van Istendal referred to Article 192.2. So the legal basis will be quite different depending on the measure that we will choose. The industry is very open to the measure. I mean, I have to say that they are very keen on the measure, but I have to be honest and completely transparent. They have a big concern also what will happen with the free allocation of allowances in the ETS. I'm not sure if the audience is very familiar with the ETS, but in the ETS, some sectors which are at risk of carbon leakage enjoy at this moment a percentage of the allowances which are given for free. There is a benchmark for that. It's not just 100% of the total emissions, but just for you to understand, there is a benchmark which is set at the level of the average of the 10 best percent producers in the EU of every specific sector. So if you are one of the best 10 producers, you get all your allowances for free for all what you emit. You can even sell your allowances if you have spare allowances because you don't need all of them. But if you pollute more than this average, of course, you need to buy the allowances in the auctioning or from other EU producers, and therefore you have an effective carbon price in the end. But these free allowances have been in the system for many years. There is a reduction of these allowances. But our colleagues in DG Clima, they are still analyzing the review of the ETS, and it will be very relevant and very important what will happen with the review of the ETS in combination with the introduction of a CBAM.
So Vicente, to summarize this a little bit, it means that it seems from your so there's not all industries are that are that interested or following up ETS in the sense that this is first of all I think something that seems to also mainly impact more energy intensive businesses first of all, and second of all in that space. As it requires you to work together with many other parts of the EC, it will require tax people to work together with different parts of their organization, because it seems to be something it seems to be at least something hybrid in that sense. So you talked about the 4 options. All these or most of these seem very interesting intellectually, but from a practical point of view will likely require coordination between various organizations within a taxpayer as well as within the tax authorities, I presume.
Yeah, no, indeed. I mean, the thing is that the CBAM has to mirror the emission trading system because this is our carbon price. So in member states, I can tell you that the Ministry of Finance are working together with the Ministry for Environment, Climate, or Energy. I mean, it depends, of course, from one member state to another, but they are working together on the definition also of this CBAM. And then depending, of course, on what the final measure will be, one ministry or another will be the chef, the feel for the subject. But in any case, either if it is a tax or either if it's an optional ETS, what has to be very clear is that the measure will mirror the ETS in one way or another. What will happen, what will change is the way it's implemented. And we will have to take into account, in particular, administrative constraints. We will have to take into account as well WTO compatibility. And then, of course, also the legal basis, which is also very relevant in this case. I can tell you that for example, the European Parliament, we are very, very close working with them. They will issue a report. The ENVI committee will be issuing a report very, very soon. They've been, of course, working with the other committees like the ECON committee and the INTA committee. They will be, as I said, they will come with a report at the beginning of February, and the European Parliament will vote on this report in March. The main preference of the European Parliament is for these notional ETS that I mentioned before. Also, not surprisingly, because then the legal basis will be 192.1, not 192.2, so that's qualified majority, and also because the measure is closer to the functioning of the ETS.
Okay, well, with that, maybe one final question, because we had a couple, but they're not coming on the screen. So, but people can read them afterwards. Vicente, there is, I think that's very clear. Also, as far as what we can expect next, you mentioned there's a proposal coming up in the mid of this year. There's maybe one thing that would be interesting to understand is the introduction or the interaction between the revision of the Energy Tax Directive. Because you mentioned it, this will mirror. We will talk about the interaction with the WTO in a later session by Professor English. But while we have you on screen, the ETD is also something that you look at. That's the Energy Tax Framework. You mentioned that there's a mirroring of ETS, so there is a carbon price put on product and activities and transactions in the EU through the ETS. There is also, Europe is also a lot heavier on its energy tax burden, and some of the questions on the ETD revision requested, do we need to look at the carbon content there? So is there anything that is being considered there as your last question?
Well, coming to your question first on the impact of the CBAM, of course, the impact of the CBAM will be different depending on the measure that we will introduce. Whether it is a tax or a national ETS, the effects will be the same. As I said before, it will only have an impact in terms of how the measure is implemented. We are at this moment looking at the impacts with our colleagues in the JRC, the Joint Research Center, but also in ECFIN and in other directorates generals of the Commission. And I can tell you that in any case, whatever we will propose will be positive in terms of reducing the carbon leakage, which is one of the objectives, but also what is very relevant and important in terms of reducing CO2 emissions globally in the EU, because it will contribute to reduce emissions internally, but also externally, and that's something good. The impacts on GDP, on growth, on jobs, etc., prices, even on trade. Some people complain that this measure might be a new trade restriction. I have to say that, and I'm very confident and very glad to know that the impacts will be really very, very low. I can't say that there won't be any impacts at all, but the impacts, of course, will be very low. So that's for the CBAM. You mentioned the ETD. We are working also on the review of the ETD. You remember that we had a proposal in 2011 that we had to withdraw because there was no agreement. That was done in 2015. So now we are coming with a refreshed view on the ETD, taking into account that since 2003, it's an old directive, many things have happened, and we want to make a difference with a new revamped ETD that will be more coherent with energy and climate policies. There is no particular interference or interaction between the CBAM and the ETD. There is, of course, more relevance or interaction between CBAM ETS, and I already mentioned that, and also between the ETD in the ETS, because as you know, one of the proposals in the European Green Deal is also to extend the ETS to transport and buildings, and that's very relevant for the ETD. As you know now, outside the ETS, only the main sectors outside the ETS are transport and buildings. If in the end they are already, or they will be included under the ETS, that for sure will have an impact on what we are doing.
Thank you very much. I think that's very interesting. You seem like you have a lot of work still to do, so thank you very much for making time available to share the latest state of the situation with us. And with that, I would like to hand back to Robert Danon.
Thank you very much, you both, for the wonderful discussion. It seems that we could go on for hours to exhaust this fascinating topic. Joachim, would you like to pick up the WTO constraints?
Yes, thank you, Chair. Thank you, Robert, and welcome everybody. And in my short presentation, I will address the WTO law constraints on possible versions of a carbon border adjustment mechanism. And for reasons of time, I'll limit myself to the treatment of imports only. And I'll discuss three different aspects in this regard: the admissibility of a carbon border adjustment as such, then the WTO national treatment requirement as stipulated in Article 3 GUT, and then very briefly, time permitting, the most favored nation requirement. And I will try to highlight the implications of those constraints for different types of carbon adjustment mechanisms, in particular the two ones that are now contemplated by the EU, as we've heard, either a carbon tax or what has been dubbed a notional carbon levy, so a notional ETS, which is seemingly preferred by European Parliament. And I think the differences between the two are not so great, and in my view, also from a WTO perspective, as you will see, are not so great. I mean, the notional levy, which is basically a notional ETS, means that you would be mirroring the ETS allowances cost on a more timely basis, probably, and maybe on a more accurate basis as compared to a carbon tax. But as we've heard, those would be linked to the ETS allowance cost. And what is maybe also interesting to know, as we shall see for a certain reason, is that Parliament, as was revealed 2 weeks ago in a high-level webinar, seemingly has in mind to base the notional carbon levy that they prefer on the average carbon price that must be paid by domestic, that is EU producers. Now, turning to the next slide, the first point would be the admissibility of border adjustments under WTO law. This is to be found in Article 2 of the GATT, and there is a restriction on such border tax adjustments in order to avoid that the members of the WTO can introduce tariff-like charges through the back door, even though they have committed to reducing their tariffs. And as you could see, if you looked at the provision, it applies to taxes and other charges, which must meet certain conditions to be admissible as a border tax adjustment. And the question here, the first problem is, does this provision then also apply to measures that are not exactly taxes because they're market-based regulations, such as the ETS? Now, if the EU were to introduce a real carbon excise tax, that wouldn't be much of a problem, would be covered by this provision. But if the EU would actually prefer a notional carbon levy, so a notional ETS, that were designed as an exact replica of the actual ETS allowance system based on current market prices on the average carbon intensity in the EU, then the question could arise, is that eligible for border tax adjustment under this provision? Because it's really just an extension of the ETS system in all but name. Now, this is disputed in literature. I go with the predominant view here because if you look at the provision, it says, or it talks about charges besides taxes. And in WTO jurisprudence, charges in a different context have been defined as any kind of pecuniary levy, any kind of liability to pay money when goods cross the border. And in my view, certainly the extension of the ETS should then also be covered because it would imply the need to buy allowances. I'll skip the two uncontroversial points and jump directly to the last bullet because there's one more problem, and that is the question, to what extent can you adjust for the domestic, that is EU cost of having to buy ETS allowances? Can you tax only a charge equivalent to the allowances cost that would fall directly on the production of the product itself? Or can you also border adjust for a so-called taxe occulte? So for charges, in this case, the ETS allowances costs that were levied at earlier stages of production. So for example, can there be a border adjustment for the cost equivalent of having to acquire ETS allowances for the energy that is, for the production of the energy that is then used for the production of the actual taxable good? I'm sorry, got to turn this off. And here, this is really problematic. This is disputed in literature, and we do not get any guidance from the history of the WTO treaties because it was disputed amongst members themselves. We also don't have much WTO jurisprudence that is helpful here. I think what the wording of the provision suggests, and which is also the predominant view in literature, is that in order to be eligible for a border adjustment, production factors that have been burdened with certain domestic charges, so in this case, EU ETS allowances cost, can be adjusted for only if the production factors are still incorporated in the final product that is then subject to the actual border adjustment. So for example, steel. And that would mean that you can't have a border tax adjustment for the ETS costs that is indirectly borne by the European products for energy inputs, for transportation, and so forth. Okay, if we go to the next slide, please, we come to the national treatment requirement. Now, this is something that is maybe difficult to digest at the first look for someone coming from an EU law perspective being used to non-discrimination as developed by the European Court of Justice for the fundamental freedom application, because WTO jurisprudence here is clearly different when it comes to the non-discrimination requirement, which is inherent to the national treatment requirement that we find in Article 3 of the GATT, in particular Article 3, paragraph 2, sentence 1, which concerns the requirement to levy taxes on imported product not in excess of like domestic products. Now, there's a number of important definitions to be aware of to apply this then to a carbon border adjustment. First of all, what does like product mean? Now we have a clear line of settled WTO jurisprudence according to which this must be interpreted economically speaking. So like goods exist when they have similar end uses, similar consumer utility, and similar objective properties. So this is more or less equivalent to the economic concept of full substitutability, as has been stressed in various appellate bodies cases and panel decisions. Now, several decades ago, we had an attempt by a few panels to establish a different approach that is actually more similar to the one that the European Court of Justice now prefers for the fundamental freedom analysis. And that was the so-called aims and effects test, relying on the policy purposes and objectives of the national measure at issue in order to establish comparability for the national treatment requirement. However, this has been rejected, firmly and clearly rejected in subsequent cases by the appellate body. And it's basically a buried concept in my view in the context of the first sentence of Article 3 concerning like products. And actually, I have to say, in my academic view, also rightfully so. And therefore, the structure and the purpose of the tax or charge is irrelevant for establishing whether two products are like. Economically substitutable products must in principle bear the same tax burden. And that then means that a larger carbon footprint of imports must in principle not increase the tax burden or the amount of a carbon levy charged at the border, because the carbon footprint is irrelevant for product substitutability. Now, that could be different in the future if consumers might become more aware of climate issues still and might make more climate aware choices also when they purchase products. But certainly this is not at present the case. And then there's another important point which you don't find on the slide, but which is also important to realize, and that is that the WTO jurisprudence does not admit jurisdictional blending, to borrow a term from the minimum tax debate. Rather, what it does is it applies a diagonal test. So no imported product must be charged a tax in excess of any like domestic product, even if some domestic products bear a higher tax than the imported product. And that means, according to a settled WTO jurisprudence, that it is not admitted in principle, it's not allowed to charge imports at the average burden, the average charge or tax cost imposed on domestic products. But rather, the border charge must not exceed the best available, and that means the lowest charge on any comparable domestic product. And as you will see, this causes some issues when we bear in mind that the Parliament wants to have an adjustment based on average burdens. And I'll come to that in the next slide, because I'll leave aside the last point here, which is a specialty which we do not need to discuss for reasons of time. So if we could go to the next slide, please. So what does that then imply actually for the measures that are currently being contemplated by the EU Commission, by EU Parliament? Well, not surprisingly, it means that there is limited scope for levying carbon taxes or a notional carbon levy based on the actual carbon footprint of the imported good, at least in principle. So that means if you go for an excise carbon tax, a real tax, then this tax should be imposed, in my view, at a uniform level on both domestic and imported products. So the link to the ETS would have to be standardized for both domestic and imported products. And it could be linked to, well, best available technology, as we've heard, the top 10% maybe, and their cost for acquiring allowances, or some other method, such as predominant method of production, average measures of production, maybe annualized based on the cost in the previous year. Now, since a levy that is imposed on both domestic and imported product would actually mean a double burden for the domestic producers, because they, in addition, pay the actual ETS allowances costs on top of the excise tax. And so for them, it could be considered, in my view, to make this tax creditable against the cost of acquisition of future ETS allowances. In my view, this should be admissible, because technically it's not a reduction of the tax, which would be a problem on the WTO requirements, but rather it's a reduction of another burden, namely the ETS burden, which is only borne by the domestic producers in the first place. Now, on the other hand, if you go for a carbon levy, which is a notional ETS, then in order to be compliant with national treatment, because national domestic products would bear the ETS allowances cost based on their actual emissions, you would have to go for a best available technology benchmark to meet this diagonal requirement, best treatment for imports available under the domestic standards for domestic products. And this is where the problem comes in when EU Parliament or the EU eventually would like to impose a higher charge based on average EU emissions on a certain product like steel or cement or whatever. For this, it would be necessary to have recourse to the exceptions under Article 20 of the GATT. And this implies a two-tier test according to settled WTO jurisprudence. The first question here would then be, is there a justification available in the list of justifications that we find in Article 20? And that's probably the case, because the environmentally related exceptions, of which there are some in the list, have been construed rather broadly in WTO jurisprudence, so that should probably not be a problem. But the second question then is, does the measure also meet the requirements that are the general requirements to be found in the so-called chapeau of Article 20? And that means they must not be a means for arbitrary discrimination or for disguised restriction of trade. And in WTO jurisprudence, this has been interpreted as sort of an acting in good faith requirement. And here the EU would really get on a slippery slope if they would have to defend the carbon border adjustment based on this measure. It's not impossible, but it's a slippery slope because you can't really be sure how the appellate body would specify acting in good faith. And now a lot could be said about that. For reasons of time, I'll highlight just two concrete requirements that can be inferred from what we see in the jurisprudence so far. The first aspect is that a measure must not attempt, so a national border adjustment measure must not attempt to impose the same policy standards as they are being promoted and enforced domestically in the EU on other governments. So they should not pressure other governments to pursue the same regulatory approach, here in this case, towards carbon emission reduction. And therefore, I think it would be advisable for Commission officials, MPs, and other people involved in the process to be quite careful not to overemphasize the need that the rest of the world follow the EU leadership in its climate protection role when discussing the border adjustment mechanism. This could make the mechanism fail under WTO law if you have to have recourse under Article 20, because you should not pressure other governments into your policies regarding climate change. And second, and related to this first point, it would be necessary to coordinate flexible certification procedures with those third countries, so to allow importers to claim a carbon levy rebate, so a reduction of the carbon levy that they have to pay for their imports, if they can prove that the carbon footprint of their product is lower than the standard calculation under the levy. And these are just two of many other requirements that you could read out of the case law so far. And then finally, very, very briefly, a last slide, most favored nation treatment. Basic question here is, can the carbon tax or levy be waived or reduced as it is seemingly contemplated, at least in Parliament, if the climate protection objectives of the measure, which we've heard about, are at least officially the only objective of the measure, if those objectives are already met by schemes in other countries, because seemingly maybe, let's say, California or the US eventually under Biden would also introduce an emissions trading system. And pretty clearly, the answer here is no, you can't do that, at least not in principle. Again, it's forbidden. It goes contrary to the most favored nation treatment. You must not treat certain nations because they mirror your regulatory system more favorable than others with respect to the levies you charge. The only thing you can do is you can treat individual producers better because they meet certain benchmarks that justify a reduction of the levy. Unless, of course, you go again for Article 20, which is really an uphill task in this case. Okay, this is it from my side on WTO. Many thanks.
Thank you very much, Joachim. I think a nice transition from the WTO segment is basically to move to the US, US perspective. So, Amanda, of course, one of the items you will be discussing is perhaps try to see what's in the crystal ball from the perspective of the Biden administration. That of course is a bit challenging, but it would be very nice to have your overall perspective at this stage, of course.
Great, well, thank you. It's very nice to be with all of you, and I enjoyed hearing the very interesting discussion to start off the panel. So thank you to my fellow panelists. And I think our chair is exactly right, that my remarks in some sense really are sort of looking into the crystal ball with respect to potential US policy with respect to climate and tax issues, as well as the potential impact of a EU CBAM and other efforts with respect to carbon pricing on US policy. To start with, as I'm sure many of us know, the US now has a new president who's, I think it's fair to say, whose climate policies will be remarkably different than those of his predecessor. In general, we should expect a return to a more multilateral approach with respect to climate policies, including, as we've recently seen, the United States rejoining the Paris Agreement. With respect to what President Biden said about several of these issues during the presidential campaign, he did propose at a high level a variety of new policies, including a policy, the details of which are not available, but would include some border adjustment related to carbon. Okay, I'm hearing some feedback, but hopefully everyone can still hear me. So I'll continue. So what was said about that in his campaign briefers was we can no longer separate trade policy from our climate objectives, as the US takes steps to make domestic polluters bear the full cost of their carbon pollution. The Biden administration will impose carbon adjustment fees or quotas on carbon intensive goods from countries that are failing to meet their climate and environmental obligations. This will ensure that American workers and their employers are not at a competitive disadvantage and simultaneously encourage other nations to raise their climate ambitions. President Biden's climate proposals in the election also included a number of other initiatives that intersected with the US tax rules, including, for example, new tax initiatives and funding for carbon capture research development, as well as some other initiatives. So of course, to implement any of these proposals, there would need to be legislation passed by the US Congress. I think it's fair to say that green-related taxes and policies have not received significant attention in the US Congress in recent years. So certainly many details would need to be worked out for anything to be passed. I do think that more discussion about these issues, as well as continued proposals of potential legislation to address specific climate policies is likely for several reasons. So looking into our crystal ball a little bit. So first, the recent elections in the US have given President Biden's party control of the US Congress, though only by a slim margin, but generally may increase the possibility of a Biden policy being passed. Second, the EU efforts with respect to CBAM and carbon pricing that we've been discussing could drive action in the United States, given a desire to keep up with other jurisdictions' efforts on climate change, and also given potential concerns about competitiveness of American exporters. Third, and interestingly, recently, some US business groups have signaled some openness to change in law to address climate change issues, which arguably may increase the possibility of some bipartisan compromise on these issues. So as I said, there are really not many details on what these policies might look like. However, there has been proposed legislation introduced in the US Congress in recent years that could provide some insight. At a very high level, several of the bills would amend the US tax rules to impose a carbon tax, as well as some sort of border adjustment, though the proposals have differed in the precise mechanisms, including with respect to what the amount of the carbon tax would be, the types of good that are subject to the border adjustments, and the methodology for the adjustment. So just to close out my remarks with a few things to look out for going forward. One question will be, of course, what happens with respect to the EU efforts, as well as whether these efforts do provide an impetus for the US to act. And then a related question will be looking forward is if there is some movement in the United States, to what extent might there be a common approach with respect to these issues, such as with respect to scope, methodologies, enforcement, WTO issues, as we've touched on, as well as some larger global standard with respect to these issues could develop over time. So with that, I will turn it back to our chair. Thank you.
Thank you very much, Amanda. We will meet again in a little while for the discussion on the CCTB and digital service tax. Jisoo, you would like to close with the UK perspective?
Sure. Thank you everyone for the opportunity and for a very interesting and riveting discussion, setting the background of the EU on resources and the green taxes proposal at the EU level. I've just been given a couple of minutes to give you a very high level overview from the UK perspective of the green initiatives. That is the UK as a third country, as you obviously all know, having recently become a third country from being a former EU member state. To my mind, from a UK perspective, the biggest question will be alignment or divergence from these EU green tax initiatives following the end of the Brexit transition period last year. Not much has been set out in the last minute agreement that was signed December last year, but there is a commitment both from the EU and the UK perspective to fight climate change, and as well as act as in a partnership with other beneficial kind of ESG initiatives. And though if we take the EU ETS as an example, of which of course the UK was historically a participant, it has left the EU ETS system but will be tasked with establishing its own carbon market based on its own carbon policy, which currently remains uncertain but has been announced to be up and running by Q2 this year. Whilst possible links have been flagged to the EU ETS and also recommended by business communities, of course, for certainty, consistency, to minimise disruption, of course, and administrative burdens, the UK government has set out that it will consider a range of options and hasn't ruled out the possibility of divergence from the carbon EU ETS system. And taking other green taxes as an example, the UK government has been spearheading a proposed plastics packaging tax, of course, that the EU green tax is also considering as a plastics packaging levy. And the UK has, to my mind, gone one step further in the implementation as an ex-EU member, but as a new third country, where it will impose from April 2022 a new plastics packaging tax at £200 per tonne and weight, applied to plastic packaging products that have less than 30% recycled plastic in weight, with, of course, de minimis exemptions and certain other exemptions relating to medical products packaging where there is necessary need. Though putting the EU own resources into light, the impact assessment from a UK perspective on the plastics packaging is fairly minimal at 220 million to 240 million per annum, as currently set out. And the government have said the tax is intended to spearhead behavioural change, and clearly there will be a change in behaviour to use more recycled plastics. So revenue raising and budgetary requirements is not one of the main reasons for imposing the new plastics packaging. Though you can see alignment, of course, with the EU in introducing the new or similar similar taxes in response to climate change and the fight against environmental damages. So the UK, of course, will be keeping a close watch on CBAM, as well as other kind of ETS developments and implementation, and the impact it may have on trade relations. And whilst it may be beneficial to have alignment, the EU still being the largest trade partner of the UK, there may still be divergence and non-alignment to the EU regulatory standards as and when agreed, depending on how many doors this may open up the divergence, say, to trade opportunities with the US or other third countries.
Thank you very much, Ji-Soon. We will, as I said, meet again in a few minutes. It is my impression that there would be a lot to say and to continue the debates, but I'm quite confident that Wolfgang Schoen, in his closing remarks, will be able to pick up some of the points that are being raised in our this interesting discussion. Unfortunately, in the interest of time, we have to move on to the next panel. So the next panel, of course, is at the intersection and closely related also to the current work of the OECD in the area of the challenges raised by digitalization, namely Pillar 1. So this panel is what's on the new CCCTB and digital service tax. Let me introduce the panel. Gunther Meyer, the Director General of the Ministry of Finance in Austria, Pasquale Pistone, the Academic Chairman of the IBFD and a Professor at WU in Austria, Michael Evers, currently an Associate Partner at Ernst & Young, and Amanda and Ji-Soon, who are already with us. Perhaps, Gunther, it's nice to set the scene. So I will turn to you for an overall introduction to the topics. Please, the floor is yours.
Thank you, Rob. I hope it works because I had to switch to my iPhone, and I hope you can hear me.
We can hear you and we can see you.
Okay, perfect. Thank you. Because I had to switch from the inclusive framework to this meeting, and it did not work with the laptop of the ministry. I've prepared a short update regarding the CCTB and the digital services tax from the Austrian perspective. Next slide, please. Let's start with the CCTB and the question, is the CCTB dead or still alive? And I would like to add a second question. Is there a link between the CCTB and the own resources of the European Union? Yeah, the idea of a CCTB has been discussed for more than 15 years. In the year 2016, the European Commission submitted a new proposal featuring two key changes. The CCTB should be mandatory for companies of a certain size, and the consolidation procedure, the third C of the CCTB, should be postponed. In the year 2018, Germany and France agreed in Meseberg, that's a village in Germany, on a catalogue of reforms, and we discussed this Meseberg declaration during the Austrian EU presidency in the year 2018. Next slide, please. Germany and France presented this Meseberg declaration, and they wanted to support the CCTB directive. Their aim was to foster the current discussion. And in the paper, you can find some very interesting general positions. I've picked out three of them. First, the scope. The scope of the CCTB directive should be compulsory for all companies. That means there should not be any thresholds, no threshold of 750 million euros. This threshold we discussed at the EU level. Second, they also suggested that the tax base should be determined on the basis of accounting principles. This is, of course, a good idea, but there was a construction problem of the CCTB directive. There are too many rules with its own tax accounting system, so there is not much room left for the accounting principles, for the commercial accounting principles. Next slide, please. Third, there should be no tax incentives, like the super deduction for R&D, because the overall aim of a CCTB is the harmonization of the tax base. And Austria supported the Meseberg idea. During the Austrian presidency, we structured the debate and we asked questions to the EU member states, for example, regarding the scope, should the scope be compulsory or for all companies, or regarding the incentives. Our problem was the outcome because there was no clear way forward. Next slide, please. So what are the future expectations? The European Commission is planning to deliver a revised proposal, but not before the OECD results on Pillar 1 and Pillar 2 have been presented. So the CCTB is still alive, but the future seems unclear and uncertain. For Austria, the CCTB has always been an important project to reduce the tax burden for businesses with cross-border activities is, of course, a very, very important issue. But to my second question, but is there also a link between the CCTB and the own resources of the European Union? There's maybe a weak connection. The consolidation could be this connection. But the consolidation would be the second step of the whole project. And at the moment, it's quite hard enough to make the first step with a CCTB. Next slide, please. Now let's turn to the digital services tax. As you all know, in the year 2018, the European Commission presented a digital taxation package, which includes two proposals. One of them was the digital services tax, a revenue-based tax of 3% of specific digital revenues of the digital advertising, the sharing economy, and the sale of user data. During the Austrian presidency, there was no agreement. So it was clear that some member states would introduce unilateral measures. And for example, Austria, Italy, Spain, France have already introduced such unilateral measures. And the US have started with their Section 301 investigations. Now let's focus on the EU, on the OECD level. The taxation of the digital economy has been one of the most urgent issues for years. In October 2019, the OECD Secretariat presented the public consultation document named A Unified Approach under Pillar 1. Next slide, please. In January 2020, the Inclusive Framework agreed on the outline of the architecture of a unified approach. The Inclusive Framework now comprises 138 member states. Today, we welcomed Samoa as a new member of the Inclusive Framework. Today and tomorrow, there are the meetings of the Inclusive Framework. And tomorrow, we will focus on digital. And maybe you are interested, you could watch the Inclusive Framework because it is streamed by the OECD. In October 2020, the blueprints on Pillar 1 and Pillar 2 were presented, and these blueprints mean an important step. And from my point of view, a substantial progress. It is also clear that a consensus-based solution comprises both pillars. But up to now, no agreement has been reached yet. Concerning, for example, the scope, should the scope be narrow or broad, only ADS, automated digital services, or also CFB, consumer-facing businesses. The agreement will also depend on the new US administration. The aim is to reach a successful conclusion by mid of this year, and that's quite near from now on. Next slide. At the EU level, we fully support the work to achieve a final agreement on both pillars. However, the solution depends on the outcome of the OECD inclusive framework. And now the question arises, can we reach an agreement? Austria, of course, supports both pillars, Pillar 1 and Pillar 2. And we think a solution at the OECD level would be much better than a revenue-based digital services tax. Thank you.
Thank you very much, Gunther. Pasquale, you may wish to address your own perspective of the digital service tax.
Thanks very much, Robert, for giving me the opportunity to present my view concerning the digital services tax. So I must say that if you look at my first slide after the title, then you may notice that I am aware of the fact that I have been changing views on the digital services tax over time. At the beginning, I was among the ones who opposed the digital services tax because I felt that it would basically scramble the international tax coordination that has taken a long time to be achieved. But then I realized, and that's pretty much in time, pretty much at the time of the Austrian presidency of the European Union, as Gunther Meyer has mentioned, I started tolerating it because I felt that introducing, at least at the level of the European Union, one single digital services tax would be better than having a bunch of them. And that could be perhaps a starting point for some better form of international tax coordination. Well, now I have reached a point that I even consider it to be desirable. As you can see from the next slide, I think that we have to take into account the very specific context that we are experiencing right now. So I think that at this moment, in particular from a European perspective, it is important to find ways to collect revenue. And this should not be done by levying additional taxes, but rather trying to find a way to steer international tax coordination, at least at the level of the European Union, inside the European Union, in order to address the tremendous challenges that Frans van Estendal has indicated before. Now, I'm not sure, because I'm not an economist anyhow, I'm not sure as to how much revenue the digital services tax may raise. However, I am actually quite sure that at this moment, if we are to go for some form of establishment of taxes at the EU level, it could be at least politically desirable. And I'm not saying desirable from a policy perspective, but from a political perspective, because the members of the European Union will also show that there can be some ways of achieving a more transparent way of funding the budget of the European Union. Fortunately, we heard France before, so that will not require further comments on my side. But if you look at the next slide, I think that there are some issues that we should address. And the next slide will see that if we consider that digital services taxes are taxes on turnover, then the first issue from an EU law perspective is that we have to address is whether they are potentially compatible with primary law of the European Union. The way that I read the Tesco and Vodafone Hungary judgments on turnover taxes, leads me to conclude that the CJEU has given green light to taxes on turnover, considering that the turnover as such is a reliable indicator of the ability to pay. And I think that in the dialogue and the technical discussion on European Union law, there is more relevance of the ability to pay as compared to what happened in the past. Not sure whether that is an EU law principle, as some of us say, or not, but still there is a lot of debate on it. And I think that there are no doubts that turnover is an indicator of the ability to pay. Now, the point is that what we have learned is that in the context in which it has been examined by the Court of Justice, it has not been regarded as given rise to factual discrimination. And that's a very important point, because we have the problems with digital services tax that it can target some entrepreneurs and some types of business. So I think it's interesting to see how the European Court of Justice has analyzed that in respect of taxes on turnover, different from digital services tax, but I think it's relevant. And I think we should also take into account that insofar as we introduce in the European Union one single EU digital services tax, that it's certainly better than having a number of disparities arising from 27 different digital services tax. Now, one more point which can make an introduction of digital service tax politically desirable at this moment is also that turnover yields revenue also in the absence of profits. And the point is of taxable profits by some countries. And I think that's quite important in order to collect revenue. And it's not about, as I said, increasing revenue, but it's about making some countries collecting revenue. But this green light that I am somehow, putting on the table, does not mean that we should consider that digital services tax are simply giving rise to no problems at all. There is no carte blanche to their introduction. I think that it's important to make sure that their introduction achieves some form of neutrality with the equivalent non-digital services. And also, this has to be taken into account from the perspective of fundamental freedoms. We should make sure that even if there are digital services taxes, the targeting of some business does not give rise to some form of state aid. Plus, I have doubts as to the position held by the Court of Justice on value-added tax and Article 401 of the EU Value-Added Tax Directive, which seems to allow almost everything unless it's basically VAT. And that is something which I'm not sure whether has been given a proper thought until now at the judicial level. However, of course, this is not meant to lack respect to the Court of Justice, but just to make constructive criticism. And the criticism is also, in my view, required from the perspective of the fact that even if we go for an EU digital service tax, we should make sure that the shaping of the nexus is done in a way that achieves some form of coordination with taxes levied on profits. And I think that this should be done in a way that we consider that when we tax turnover, we're not taxing gross income, we're not taxing something in lieu of income tax, we're taxing something in addition to it. So I think that's extremely critical, and I've been writing recently on this. If you look at the next slide, we go into the dilemmas, which are also the final part of my presentation. And the dilemmas are 6 and are policy dilemmas. And I thought that because IFA has graciously made available to us this opportunity to discuss on these issues, I think it's a good opportunity to share my thoughts with you. First, should we go ahead with an EU digital service tax if there is no consensus at the global level? Now, of course, if there is one, certainly it's good. It's very good to have a global measure and global coordination in the framework of Pillars 1 and Pillar 2. But my suggestion is that the EU should go ahead also if there is no consensus at the global level. And that is because at this moment, the EU budget has significantly increased, and funding the EU budget with a digital service tax is more transparent than just with transfer of revenue from the state's budget as it currently happens. So it would be a step in a good direction. And in my view, it can also help, achieving some form of coordination at the global level. I don't think, and here we go to the second dilemma, I don't think that the introduction of an EU digital service tax will spark up a new tax war with the US. And I'm not saying that just because of the fact that the US has a new administration, but I think that it's good that at the global level, there is a mechanism of checks and balances across different blocks of countries, and the EU has different needs and different features at this moment from the US. It's a digitally important country, or a digital developing country, if we want to call it like that. And I think it's important also that it aggregates consensus on other countries in the world in this respect. The third dilemma, it's an intra-EU dilemma. And the point is whether the EU should keep all the revenue collected with the EU digital service tax at the supranational level or share it with the member states. Now, sharing it would be an option, but the point is, how will the EU be able to share? But even if the EU doesn't share it, the issue is that if the digital service tax contributes to fund the EU budget, that will have to reduce the contributions by the member states. So having it at EU level doesn't completely solve the problem of how it is going to affect contributions by the member states of the European Union to the EU budget. And here we go to the fourth one. Should the relations with profit taxation be regulated? Yes, absolutely yes. And how? I think that this is something which really depends on whether we introduce an EU digital service tax without a global tax on digital service, without a global agreement, because in that case, there may be activity required at the level of the European Union and its member states. Whereas if there is a global digital service tax, that is a matter which can be addressed at the global level directly. Should the relations with the EU VAT be regulated? Yes, absolutely yes, because the fact that digital services are liable to an additional tax as compared to non-digital services, which are also liable to VAT but don't get this extra layer of tax, is in my view something that should be given a proper thought. Now, finally, should the EU apply here the in foro interno, in foro externo doctrine? So in other words, insofar as we have an EU directive within the European Union, should the EU also step in when it comes to the relations with third countries? Well, I think it's unavoidable, but that doesn't mean depriving the countries of their powers. It rather means exercising them harmoniously within the European Union and in relations with third countries. Well, that's pretty much all from me for my presentation. Back to you, Robert. Thank you very much.
Thank you very much, Pasquale. Of course, discussion on digital services tax has wider implications. And one of these implications, I think you touched upon it, is the issue of compatibility with tax treaties. And to take the discussion on that front, I'm welcoming now Michael Evers. Please, Michael, the floor is yours.
Thank you, Professor Donald. And good afternoon to all. While we're going to my first slide, or actually the second slide after my title slide, I wanted to look at two aspects when it comes to tax treaty compatibility. A lot of the discussion so far has been around the treaty terms, and that has affected how DSTs that we have seen introduced, how they have been designed. But I also want to discuss with you the compatibility with the object and purpose of tax treaties. So if we move on first to that first part on the treaty terms, so that's when you would really focus on the actual terms of the treaty. If you would look at the OECD Model Tax Convention, the big question is around the definition of taxes covered. So I guess treaty experts in the audience are familiar with that article. If we look at the next slide at a few key elements of that definition, so we're talking about taxes on income. That is a relatively so that's here presented as a closed definition, but then described in such a broad way that all types of income-related taxes could be part of that. So that is also clear from the second paragraph, pointing to a very broad application. It is not only comprehensive income; it could also be a certain item of income. There's also a sort of a reference even to to payroll taxes, so even taxing the income of others in the hand of the employer could be income as described in Article 2. Then there typically you find a enumeration of the actual taxes that just for clarification purposes for OECD model compliant treaties, and then also a reference to treaties that are identical or substantially similar, but that are introduced at a later stage. So there's definitely the intention to apply to a broad range of taxes and also to apply dynamically. So that could also affect a DST if it would be introduced at a later stage, so after the conclusion of a tax treaty. Important thing to note, as we will see on the next slide as well, is that there are important deviations from the model. You'll see that also in the US Model Tax Convention and the treaties that are actually based on that. The US treaties with other countries include a very specific list or a really closed definition, and in principle only the taxes mentioned there would be subject to or would be within the scope of the treaty. Now, with that in mind, moving on to the next slide, of course the issue would be if you would qualify a DST as an income tax, you would run into the treaty limitations, in particular of Article 7, together with Article 5 for the PE threshold. Come back to that in a second on what that would mean. But even if you would say, yes, a DST is an income tax, depending on how it has been designed, you would be, in principle, confronted with those limitations following from that article. There's still the question around to what extent would you as a taxpayer who is subject to that DST and have access to that treaty benefit. Of course, keep in mind that it also depends on the type of legal system of the jurisdiction applying the DST. If there's a monist or dualist system, and can it be a form of a treaty override, like in principle would be possible in a system like that of the US or the UK, or in a monist system like in France or the Netherlands, you could take the issue directly to court and try to get access to those treaty benefits immediately. Just wanted to flag that out. That again, it depends also on the legal system of the country concerned. I think in Italy, where we have a DST now, I'm not an expert on Italian constitutional law, but also there, while Italy has a dualist system, there is a way to take that to the constitutional court. So that is also relevant for the application in an individual state, but all the countries that have designed their DST so far, of course, have been keen to design a DST in the way that they could avoid all these questions. So they tried, in most cases, the DSTs are based on gross revenue, not creditable against corporate income tax in most instances. Sometimes also not branded as a tax, but branded as a levy. So we see also the reference to the word levy in the European context, and in most cases also legislated separate from the corporate income tax system or the applicable laws. Well, the question is that strategy successful? Does it then sort of start to look at something that is different from an income tax? Well, so far I haven't seen many challenges yet, but most of these DSTs haven't been around for too long. I think the more important question is, does this sort of behavior of the legislators result in good tax policy? Because probably deep in their heart, they also know that a gross-based DST has very strange effects from different angles that I will touch upon, but they insist on keeping it gross tax for it not to be seen as an income tax. So some of the downsides, but also the positive sides of the DSTs were already mentioned by Professor Pistone. But just to highlight a couple of downsides I see, especially if it's gross-based, turnover-based, you, of course, indeed are taxing also companies that are not profitable. So that has pros and cons on its own, as Professor Pistone also suggested. But what does it mean indeed for companies that are still in their startup phase and are still to make profits, to become profitable while they run into these gross DSTs? Another issue with having this DST separate from the corporate income tax is that tech companies that are relatively local provide their services locally. The local champions, let's say, they already pay the corporate income tax and they will get a DST on top of that, while their competitors, let's say the big tech companies with scale without mass presence, they would then only pay this turnover tax. So there's still not an equal situation, equal treatment of those two competitors on the local market. So that's an issue on its own. So there are some questions around good tax policy that are resulting from the choices that legislators have made in their attempt to design it in a way that it makes it compatible with tax treaties. But then moving on to the other issue I wanted to discuss, the object and purpose of the tax treaties. There are different ways to look at the object and purpose of the tax treaties. I would like to look at it from a very high level and a historical level. So if we do that, if we move on to the next slide, I have this very quick overview of where we got to in the last 150 years when the tax treaties started to develop the late 19th century in tandem with corporate income tax systems or income tax systems in general. Tax treaties, albeit negotiated on a bilateral way, it sort of initiated a body of law, so to say, that became sort of the international standard. And as part of that, we have a separate entity approach. Countries have chosen not to apply something like formulary apportioned group-wide taxation, etc. All of that was developed and I think embraced up until at least 2012. That's where I stopped this timeline to be able to zoom into the timeline for the period after that. That will be on the next slide. Because 2012, I actually mark as the beginning of the BEPS project, formally launched 1 year later. But in 2012, in the castle of Chantilly, the Bureau of the Committee on Fiscal Affairs started discussing the scope of the BEPS project, and also the issue of what became later Action 1 was on the table there, with countries like France and India already pushing for this, but the US pushing back. And in particular, also Germany warning from the fact that if you're going to discuss this, then you will basically discuss the principles of the international tax system, and you would need to look at the existing framework, also tax treaties more fundamentally. And the Germans in particular, were also afraid of a slippery slope that you would enter once you start discussing taxation of tech companies. Now, fast forward, of course, we all know that the whole discussion around Action 1 was not a smooth discussion. So countries and changed positions over time, though. I think a big change happened around the introduction around the US tax reform around 2017, also with the introduction of BEAT and GILTI. So it was, of course, that also then the US changed its position towards Action 1 because they changed their position unilaterally. But it's also where you see a shift in the thinking of the other countries. The initial response of some countries, also in the Committee of Fiscal Affairs of the OECD, was that they thought what the US was doing was actually contrary to their tax treaty obligations, that the US was not acting in good faith. In my impression is that later on, countries actually took some inspiration from what the US has been doing. If you look at what is in the blueprints now, in particular also in the blueprint on Pillar 2, the very thick booklet, but there is a chapter at the end on implementation where there are also some statements around the compatibility of the proposed rules. I know it's about minimum tax, I know it's not about digital services taxes, but there are some very bold statements about the compatibility of the income inclusion rule and the undertax payment rule in regards to the tax treaty compatibility, where basically the OECD seems to suggest that the countries can do almost everything with their own residents, and I think that is in contrast with what with sort of the original intent of tax treaties, where there is clearly an allocation of taxing rights between source and resident states, and the treaties clearly set boundaries. But perhaps countries are changing their mind. I have different views on what exactly the object and purpose of a tax treaty is. Maybe stretching their interpretation of tax treaties. just moving on, because I think that raises a couple of questions. If we go also to the next slide, I personally, I would think that if countries would change the international tax system, they would do that. They will need to do that by rediscussing the allocation of taxing rights for the EU member states. If they want to have a DST, they can do that, of course, do that among themselves. It will also raise the question what to do with the tax treaties between the European member states. I think that will be already difficult enough, but I think it will be an interesting question to look at what would be the impact of EU digital service attached to treaties with third states, and who will be taking care of that treaty relationship between the EU on one side and the third states on the other side. Professor Pistone was referring to economic blocs that need to talk with each other. I think that is probably the approach that makes most sense. Of course, we have the negotiations within the inclusive framework on BEPS, 137 countries talking with each other on an equal footing. Traditionally, multilateral negotiations between a large group of countries have never been successful on the allocation of taxing rights. Maybe it makes more sense if those negotiations take place between different blocs, so maybe EU against the US, and they together can find a way where they not simply potentially override treaty obligations, but really work together to change the international tax systems and just modify the tax treaties as they should be modified. Clearly, the EU could be considering to just use this digital levy as a way to create leverage in those negotiations with the US. Question is whether that is an appropriate use of the EU's legislative competences. Perhaps not. I mean, the competences are there to improve the internal market, but maybe at the end of the day, the internal market can also be approved if there's a sort of a modernization of the allocation of taxing rights between the EU and other countries. So one way or another, whether or not they think it's a good way to use the legislative competence in that way, I think this is what they will be doing. I think it's quite likely that this digital levy in some form will see the light of day. But I hope it will then only be a sort of an interim step towards a more solid and more fundamental revision of the international tax framework, including a proper revision of tax treaty obligations. And with that, I want to give it back to Professor Donald.
Thank you very much, Michael. Just one thought for you, one question for you, since we have a couple of minutes. It strikes me in your presentation that you've placed the emphasis on the object and purpose of treaties. Now, since at least 2003, the marker of treaty abuse by taxpayer is basically to conflict whether a behavior conflicts with the object and purpose of a treaty. So would you say that basically the same should apply to states to regulate their treaty obligation? And do you see a symmetrical situation in the sense that the behavior of taxpayer is tested against the object and purpose of the treaty? And would it be not normal to test the behavior of states also against the object and purpose of the treaty? In other words, I guess the question I'm asking from a provocative manner is whether the introduction of a digital service tax amounts to tax treaty dodging.
Yeah, I mean, that is linked also to the good faith principle, right? That the countries need to adhere to. That's something between them, between the states. This is exactly the point that was raised by some of the countries initially in response to the US tax reform. They were basically saying that the US was not acting in good faith, so I definitely see there is that link. But yeah, what can you do with that? I don't see immediately countries also taking a case to The Hague, to the International Court of Justice. But the issue is definitely out there. I guess at the end of the day, we want to even avoid these kind of tensions and hope that the governments will choose the royal way and find a way to really change or to modify those treaty obligations, or to come up with a different framework. So far, I'm, as I said, not too confident yet about the multilateral negotiations between so many countries. So probably we need a different game theory approach with some blocs talking to each other and sooner rather than later, I hope.
Thank you very much, Michael. Yes, of course, you mentioned the US. The US is critical in the discussion, so I will turn to Amanda.
Great, thank you. And if we could go to my slide with a few bullets, that would be great. Thank you. So a major question that's come up in several of the remarks of the panelists has been how the OECD and EU DST work will interact with US tax and trade policy, which in turn raises the question again of what approach will be taken by the new Biden administration. To start with, there will certainly be other priorities in the tax and economic area for the administration, given the continued pandemic, but DSTs seem likely to continue to be a major issue for the administration, given the significant impact on large American tech companies. So to start with, I want to give some context for those who are eager to see if the new administration's approach to DST differs from that of the prior administrations. I note first, we are only a week into the new presidency, so much still to be done in terms of forming the team and setting policies. Earlier this week, there was a new U.S. Treasury Secretary, Janet Yellen, who was confirmed. And the team that is going to be responsible for advising and setting the administration policy on these issues is still being formed, though several people, of course, who have been working on these issues, including since BEPS 1.0, do remain and will continue to play an important role. So we can expect the administration's approach on both the tax front and the trade element of the DST front to continue to develop in the next few months. So far, we've heard a few high-level statements about the approach, but not a lot of details. So as an example, Secretary Yellen has stated that the administration will commit to vigorously engaging in a cooperative multilateral effort to address base erosion and profit shifting through the OECD G20 process and to working to address the tax challenges raised by the digitalization of the economy in that context. So going forward, I'll have a few questions in terms of the substantive areas that the new administration will need to be grappling with in the coming months. So first, there's the question of the US approach at the OECD. The new administration will likely be weighing numerous issues, including is a multilateral agreement at the OECD politically feasible just in the United States, putting aside the relationship with other countries, but within the US itself, given the significant impact on US tech companies, as well as concerns that have been expressed by a number of members of Congress from both of our political parties. Another question is some OECD agreement, which will require some compromise by the US, better for American companies than the continued proliferation of unilateral DSTs. And then, of course, what would an agreement look like? Presumably, it would not include the safe harbor approach that was floated by the previous US Treasury Secretary, given that that has not enjoyed any broader support since that was raised. And then what I'll speak to next, what is the role of US trade law and US tax law in creating a potential incentive for other jurisdictions not to continue to adopt DSTs? So on that last point, as we've heard several of our panelists mention, the United States Trade Representative in the last administration did open investigations into whether the adoption or contemplated adoption of DSTs in numerous jurisdictions, including the EU, is unreasonable or discriminatory, or whether it burdens US commerce. So far in the reviews that have been completed, the trade representative has concluded that they are. Some tariffs were previously announced in response, specifically with respect to French origin goods. but those tariffs have been subsequently suspended, and no specific actions with respect to other countries in terms of actually instituting tariffs have yet been taken. So going forward, the new administration will need to decide whether it wants to continue to use tariffs or threat of tariffs as a tool in discouraging the proliferation of DSTs or potentially encouraging some sort of multilateral agreement. With respect to US domestic policy responses, I would note that earlier in 2020, the US Treasury and IRS did propose some regulations that would impose a new jurisdictional nexus requirement for a foreign tax to be considered a creditable tax. These are proposed regulations. So a question to look out for will be whether the new Treasury moves to finalize these rules. The regulations would impact the creditability of DSTs, though they are not limited to them and have been in the works, according to members of Treasury and the IRS, for several years. So not limited to DSTs and could impact a broader variety of new foreign taxes that have emerged in recent years. So basically, at a high level, the regulations would look to whether a tax that is imposed by a non-resident of a country is imposed on the basis of three potential types of nexus. One, what's essentially in-country activities nexus. Two, a sourcing nexus, where the sourcing nexus would essentially look to whether the source rule being used by the jurisdiction is similar to existing US source rules. Or a property situs nexus, looking to whether the tax is imposed due to some in-country property. The location of customers critically would not give rise to nexus under these rules. So the proposed regulations are currently in the notice and comment process in the United States. So it's something that could be, the new administration will have to consider its approach to within the coming months. Treasury has stated that if there is an agreement at the OECD that includes the US and addresses a new framework for allocating taxing rights, that it does recognize that other changes to the foreign tax credit system may be required at that time. So that would be something to look at in the future if there can be any agreement on these issues. So with that, I will turn it back to our chair. Thank you.
Thank you very much, Amanda. Jisung, some quick closing remarks from a UK perspective.
I'm conscious that we're running tight on time, so I'll just share a couple of thoughts from, again, the UK third country perspective, being a former EU member, and initially on the CCTB, or the revived initiative on the common corporate tax base. It's no secret that the UK probably has been opposed to the CCCTB from its inception, whether it's because it impinges on tax sovereignty, of course, a matter in which that was hot as part of the Brexit referendum debates in any event, or whether it hinders healthy tax competition between jurisdictions, or brings about business uncertainty on different applications or interpretations of the principles that may be agreed on the common corporate tax base, but applied differently and interpreted differently across different member states. I mean, with Brexit, it seems even clearer, to my mind at least, that the UK will not be looking to align its corporate tax system with anything that may or may not come out of the EU common corporate tax base discussions. But against that backdrop, although divergence may be the trend, or it's tempting to say that it is the trend, it's also worth noting that the UK has been, of course, an active participant in the global stage of the OECD 1 and 2 discussions, not to mention also BEPS projects gone past in relation to corporate taxation and the fair allocation of taxing rights across not just digital economies, but all corporation tax. So, and from my fellow panelists as well, it's clear that there may need to be some alignment and negotiations between possibly blocs, whether that be at the EU or OECD level or US, to reach that global resolution. And the UK will be a critical part of that. So, and will be signing up to whatever that may be agreed at the global resolution. And just a quick couple of words on the digital services tax in the UK, which did come into effect from April last year. It's broadly a 2% turnover tax, very specifically targeted at certain highly digitalized businesses with limited physical presence in the UK, but earning revenues attributable to UK users. That includes only social media services, online marketplaces, and internet search engines, with a de minimis applicable to group digital services revenues of over £500 million, attributable revenue to the UK users being over £25 million as well. The UK has clearly stated from announcement that it will be, or is, the UK government is committed to disapplying its DST pending satisfactory resolution at the global level. The introductions of the UK DST, some say, signal some skepticism given the differences of opinion between countries that global resolution will be reached, or at least a satisfactory one from a UK perspective. But it's also worth considering that actually as Michael pointed out, the inception of the OECD BEPS project has nearly been a decade ago, and with no possible resolution or recommendations or a path forward necessarily being agreed at a global level now, the UK DST is an interim placeholder until the point in which resolution could be received. There is, meanwhile, not so much revenue impact, with the impact assessment being minimised to 280 million at its inception, projected forward to increasing to 500 million in 2024, 2025. So not the big revenue raiser that one might expect to be part of if an EU digital tax or an equivalent was introduced as an own budget resource. But it clearly has the big headline grabbing tax mention, with multinational enterprises paying their fair share between the misalignment of where profits are allocated and taxed and the place where value is seen as being created. One final remark, of course, is that the UK government has stated that it could consider in possible discussions with the US trade deal that if the UK DST was met with US opposition, such as tariffs, that it would consider changing or withdrawing the DST. And so at the moment uncertain given the US administration change and how the US will respond, but something that I think will be interesting going forward to monitor.
Thank you very much, Jason. Before we turn to Wolfgang, I would like to welcome a special guest for a final intervention, Dr. Monika Wünnemann, who is the head of department at the Federation of German Industries, and whom we've asked to give a perspective not only on this last segment, but also on the previous one, which perhaps would add a nice final concluding remarks before those of Wolfgang Schön. So Monika, please, the floor is yours.
Yeah, thanks, Robert. And first of all, thank you for giving me the opportunity for a short comment from the point of view of the German industries. At first, some words to the carbon border adjustments. BDI, as the voice of German industries, welcomes and supports the Paris climate targets. Green taxes and carbon border adjustments are potentially make a major contribution in order to achieve the global climate targets. An absolute requirement, however, would be a close coordination and cooperation with our trading partners. At the same time, major parts of German industry have strong reservations about carbon border adjustments. It is questionable whether they are suitable for ensuring carbon leakage protection and creating a level playing field. Carbon border adjustments would affect all industries in Germany, but especially, for example, the whole metal industry or basic chemistry. So a uniform application to all market participants without exceptions and no additional administrative burden for the companies should be the favored option. So finally, some words to the digital services tax. In order to address the tax challenges of the digitalization of the economy, a global consensus of the OECD's proposals, Pillar 1 and 2, which also applies to Europe, is needed. From our perspective, unilateral measures are to be rejected, and also a European digital services tax would be ineffective. For German industry, a global solution is essential, and efficient and binding mechanism for dispute prevention and dispute resolution are of particular importance. So these are my short comments on both topics, and thanks again for giving me the opportunity to share my comments with you.
Thank you very much, Monica. Yes, so I think it's time to close the conference with the wrap up by my colleague and friend Wolfgang Schön, who is the director of the Max Planck Institute for Tax Law and Public Finance in Munich. I think, Wolfgang, you heard a lot of discussion, which probably will shape what you have to say. So please, the floor is yours.
I am somehow dark. Someone has to start my video.
Yes, so I think Cécile can start the video so that we can see Wolfgang.
Okay.
Yes, we can hear you and we can see you.
Thank you so much, Robert. Well, ladies and gentlemen, dear friends and colleagues, dear members of IFA and EATLP. We are now close to the end of the first online webinar jointly organized by the European region of IFA and the European Association of Tax Law Professors. And the first thing I want to do is to congratulate the organizers of this event, in particular Guglielmo Maisto and Adolfo Martin, on this achievement. We need cross-border exchange of views and visions, of arguments and opinions more than ever. If Europe in general and the European Union in particular are meant to have a meaningful political influence in the global arena, this global influence must grow out of a pan-European debate on policies and institutions. Against this background, the organizers can be proud of having assembled such an impressive array of high-level speakers from inside and outside Europe and from practice, politics, and academia. The overall topic of this conference was reshaping the EU own resources and its impact on third countries. Given the immediate impact of the COVID crisis and the European Recovery Fund, Next Generation EU, established only a few months ago, this is a timely topic to choose. It is fair to say that the COVID crisis brought to light manifold deficiencies of the current system, which have been in need of forward-looking solutions for many years. In fact, the debate on the future of the EU's own resources has been ongoing for many years. In fact, the institutional issues, like the capacity of the EU to take on debt or to levy its own taxes, took off many years ago. And the Commission's proposal to abandon the unanimity principle in fiscal matters dates back to President Juncker's term at the helm of the Commission. Thus, it dates back to a time when Corona was nothing more than a Mexican beer brand. The COVID crisis has made this debate more urgent than before. But we should be cautious. Wherever we look in economic and fiscal affairs, we are confronted with manifold political demands which have been promoted from different sides of the political spectrum for a long time, irrespective of COVID, and which are now relaunched under a new heading. National tax legislators know that just the word COVID can serve many purposes. Some plead for dramatic tax increases in order to fight inequality and to pay for public spending, while others press for dramatic tax reductions in order to get the economy going and create new after-crisis jobs. Our current debate should not be about short-term fixing. It should be about the long-term future of the European Union and its fiscal constitution. In my view, we should avoid premature and half-baked solutions which are driven by today's urgent political needs, but which do not offer a reliable and sustainable layout for the years to come, when hopefully COVID will have become the fading memory of a nightmare. In his introductory speech today, Frans van Nistelrooy presented us with an impressive panorama of some of the main building blocks of a reformed fiscal constitution for the European Union. Two of these stand out: the introduction of dedicated EU taxes, as opposed to mere harmonization measures as we know them, and the replacement of the unanimity principle by qualified majority voting. Some speak of the need for a Hamiltonian moment in European fiscal law, reminding us of the impact of Alexander Hamilton's crucial decision in late 18th century America to move public debt from the level of the states to the Union itself. This not only provided relief for the over-indebted individual states, but it also moved the United States as such towards true statehood. In my view, we should get the broader perspective before we enter the field of taxation. Before we talk about tax revenue and how to raise it, we should talk about spending. Where should spending capacity lie in the future? With the European Union, with member states, or with subnational or municipal entities? The principle of subsidiarity, which is still relevant for Europe, requires that we should first find agreement on the issue at which level of government spending decisions are made and budgetary needs have to be met. Theoretically speaking, the answer should be clear. The EU should spend its money on Europe-wide public goods, like transnational infrastructure, foundational research, and other policies which require joint action. Just yesterday, Ursula von der Leyen, in her capacity as President of the European Commission, highlighted the fact that joint development of vaccines is not only a European, but a truly global common good. On the other hand, we would have to discuss to what extent the funds available to the European Union should be used for redistributive purposes in Europe, including which kind of redistribution, from rich people to poor people, or from rich countries to poor countries, which is not the same thing. When the 750 billion euro recovery fund was in the making, there were heroic assumptions about the way it should be spent, making Europe greener as a whole and addressing other EU-wide public goals. The outcome was different. Large parts of the money will be given to national governments to fill gaps in their budgets and to foster national economic policies against the background of rather soft reform commitments. The original 500 billion grant plan put forward by the Commission included, rightly, proposals for collective EU investment in areas such as health, migration, and various other EU programs. However, much of that was heavily cut back to make sure the main part of the pot was kept to fund countries' individual post-pandemic economic recoveries. Is this really the way we want the EU to work in the future? Raising money at the EU level, but spending it at the national level? Can we really say that there is a clear policy in the background which allocates the creation of public goods or institutionalizes redistribution on a rational basis and at the right level of government. I don't want to go deeply into the current debate on COVID and in particular the European Union efforts for a coordinated strategy to secure and to finance swift and wide-ranging vaccination. But we all can see that the division of labor between the Union and the member states and the consequences of this division of labor have to be addressed in a meaningful manner before we can talk about moving up further fiscal competences to the EU. I do not have a final answer on this, but I know that we badly need this debate. The main part of this afternoon was devoted to European tax policy, in particular a range of new instruments, which are meant to create flows of revenue to the European Union's coffers. We were given impressive presentations by leading practitioners and academics on burning issues of environmental taxation, from the plastic tax to carbon border adjustments, and we heard about the resuscitation of long-standing proposals like the CCCTB or the current state of more recent proposals like the digital services tax. We did not only hear about the policies behind these proposals, but also about their compatibility with higher-ranking international law, in particular, the law of the World Trade Organization. There are even more proposals floating around, like the financial transaction tax, which never makes progress, but never is abandoned as well. But one thing is sometimes easily forgotten at this point of the debate. When we look at those taxes, any tax that did make no sense before COVID and which was rejected for good reasons by many countries in previous years has not changed its problematic nature just because COVID came up and the EU needs additional resources. Again, it is not my task at this point of the conference to give a final judgment on the merits of these proposals. Some, like environmental taxation, follow a well-conceived scientific concept, which aims to allocate the social cost of environmental damage to those who are responsible for that damage and should rightfully be forced to include this cost when they calculate the profitability of their operations. Some, like the digital services tax, seem to be not that well-founded, as they combine a fuzzy but rather critical view of large internet firms and their social and economic power with the well-known interest of each government just to raise more revenue. The CCCTB, on the other hand, is and has been a truly European project, as it makes sense only in a multilateral situation like the European Union. Its merits have been discussed at length, and the only thing I deplore is its change of purpose. It started out nearly 20 years ago as a project to improve the internal market and to reduce compliance costs of cross-border business. But in recent years, the European Commission reshaped its CCCTB proposal in order to present it to governments as an anti-avoidance tool. In a certain way, this project has been overtaken by recent developments at OECD level to empower market countries rather than production countries. But still, it's a remarkable concept which deserves further consideration. But it is a harmonization measure, as Franz van Istendahl and Gunther Meyer made clear. It is not by itself a source of revenue for the European Union. When it comes to the way forward with all these proposals, many experts have formed the opinion that the principle of unanimity is the major obstacle, that it should be removed and give way to qualified majority voting. Again, it is not up to me to draw binding conclusions on that proposition. But it may well be that we are not simply locked into this binary choice between unanimity and majority voting. We should try to come up with a fiscal constitution that allows for more flexibility than we currently have. Take one point. The principle of unanimity works both ways. You can only legislate in fiscal matters by full agreement, for example, in order to enact a directive, But if you want to get rid of it, the same procedural rules apply. Whatever will be achieved after years of infighting and political bargains is bound to be here to stay. This can be favorable to the taxpayer, as we can see when we look at the Interest and Royalty Directive, which many governments today rather deplore. But it can also be disadvantageous for the taxpayers, as we can see when we look at the Anti-Tax Avoidance Directive, which was enacted surprisingly swift back in 2016 and created hard and fast rules, which today many regard as overprotective and badly designed, but still it will be extremely hard to retract from this position. We need new forms of flexible legislation, like sunset clauses, limiting the time frame for a harmonization measure. Or we can think of opt-out rights for member states if harmonization measures look increasingly dysfunctional. Majority voting should be established at least for the revocation of harmonization measures. Take the digital services tax. Why do we want to force each member state to levy a DST? A framework directive, which would simply set a harmonized template for any DST, would serve the internal market without encroaching massively upon each country's fiscal sovereignty. As regards the CCCTB, the biggest problem is that we simply do not know whether and how it will work out and what behavioral effects it would have on companies and tax administrations. No country should be felt or bound to be locked in without knowing what the future brings. I would feel much better with the CCCTB if it were not cast in stone by a single legislative stroke. Member states should agree to apply the CCCTB for an experimental period of, say, 5 years, and be entitled to opt out if they feel eventually overwhelmed by the relocations of business or the behavior of other member states' tax administrations. To put it differently, a flexible regime for the CCCTB would force all member states to cooperate in a fair and trustful fashion for the long term. As you all can see and hear, the webinar we had today provided us with rich food for thought. I am grateful to the organizers and to the many experts we heard today. I very much hope that this will be the beginning of a long and fruitful interinstitutional exchange between IFA Europe and EATLP. If we want European democracies to prevail, and if we want the European institutions to prosper, we need forums like these, which contribute to the coming into being of a truly European public, which is the basic requirement for what our ancestors have called an ever closer union. And with this, I hand back to the organizers of this conference.
Thank you very much, Wolfgang. I will myself hand out to Guglielmo for some closing remarks.
Thank you, Robert. So we really are at the end of this event. So thanks to the speaker, thanks to the chair, thanks obviously to the audience, and please wait before leaving the platform and enjoy again the video, the opening video, which should be on now for a few minutes, which also shall report the name of the supporters of our event, and see you soon at the next event. We hope to announce soon when we shall be having the regional conference, which was originally scheduled for May 2021, and which shall most likely be postponed in the same year. So thank you again, and have a good evening. Bye-bye.